All right, good afternoon, everyone, and welcome to the historic courthouse. I'm joined this morning or this afternoon by Associate Judge Easterly and Associate Judge Schenker. We have one special sitting today in the matter of William Davidson, AKA MUHAYMIN Muhammad versus United States. All right, counsel, are you ready to proceed?
Good afternoon, and may it please the court. Ariba Jibril on behalf of appellant MUHAYMIN Muhammad. I would like to reserve 2 minutes for a rebuttal. The trial court erred by finding that Mr. Muhammad was still dangerous, despite the BOP's own metrics and his expert all concluding that he was at low risk of recidivism, because of his inability to complete sex offender treatment that was not available to him, and a 2016 disciplinary infraction for filing repeated grievances. The trial court additionally erred by improperly rejecting evidence of non-dangerousness and holding Mr. Muhammad to an elevated standard of proof. The court dismissed Mr. Muhammad's pattern score because it could not guarantee that he would not recidivate, his expert's opinion because it was produced as a written report, and his letter of remorse because it was not accompanied by live testimony, even after telling him twice at the hearing that his failure to speak would not be held against him. Finally, Doe and Riley conclusively establish that the trial court erred in its interest of justice analysis because it relied on sentencing principles from outside of the IRA statute. Therefore,
Can I
yes.
jump in and just ask you a little bit about your first point about the trial court erroneously relying on the failure to enroll in sex offender treatment sooner. The record shows that he put himself on the waiting list in 2015, but the record is silent about why he wasn't on the waiting list earlier, whether he tried to get on the waiting list earlier. And in your briefs, you contend that prior to 2015 is really not relevant. Can you talk a little more about this, particularly in light of the fact that the IRA standards allow you to look at or require the judge to look at the entirety of the record?
So, Your Honor, I think what's relevant here is what Mr. Muhammad did try to do, and that's what's in the record, which is his 2015 which is the actions he took in 2015 to get on the wait list.
But isn't it also relevant, if we're looking at the totality here, why he wasn't on the, I guess whose burden was it to show why he hadn't either been required to take sex offender treatment earlier, had not sought it, or it was not available?
I believe, Your Honor, that it's not clear that that treatment was even available. And so for the court to rely on that when there's no evidence to show that he could have even signed up, it doesn't really show anything about who he was.
But
It's not.
if the court feels that something was missing from the record,
Yes.
which he seemed to feel with respect to this issue of
Yeah.
treatment, whose burden is it under IRA to show or to put that in the record?
Well, the court actually has the ability under the IRA statute, if they have a question, to ask for the record to be expanded. And that's so the court, if that was a relevant factor that the court was missing, the court could have asked for it. Mr. Muhammad's burden is only to show that more likely than not it's only to show by a preponderance of the evidence standard. And we believe by showing, that in 2015, that is almost a decade ago, he did try to seek this treatment. There's nothing else in the record to indicate that this treatment was otherwise even available to him. And what we know is that it's still not available to him because he still can't access it.
Didn't Mr. Muhammad put in evidence that as of the time of his application, that sex offender treatment was not recommended or required for him?
Yes. So Mr. Muhammad has, Mr. Muhammad's counsel at the hearing shared with the court that his 2023 individualized programming plan did not include sex offender treatment as a short or long-term goal.
So that's from BOP.
Yes.
And without that recommendation or without that sex offender treatment in his individualized plan, can he get off the waiting list?
So it's very unlikely, and the DOJ in one of their budgetary reports to Congress shared that someone is likely to get off the wait list if they are medium or high risk of recidivating. Mr. Mohammed is at a minimum risk for recidivating, and that comes from BOP's own assessment, which is the pattern tool.
So we've got a minimum risk of recidivating, and we've got BOP
Yes.
not putting sex offender treatment in his individualized plan.
Yes, so he's very unlikely to get off this wait list.
So counsel, I understand that sort of factual piece. But sort of as a legal question or as an IRA question, why can't a court say, or can a court say, whether it's under factor 3 or maybe under factor 5 or any of the factors, maybe even factor 11, what's your position on whether a court can say, look, I get that you were on the wait list, you tried, it's not your fault, you did not get the sex offender treatment, but in my view, and again, putting aside this case where I know you had expert testimony saying he didn't need it, but could a court say, I think you needed it. It's not your fault that you haven't had it, but you need it to not be dangerous. And so I find you haven't satisfied the dangerousness prong.
I think that would be inconsistent with the text and purpose of IRA. Certainly, that would be a much harder case than what we have here, because of course we do have other evidence of non-dangerousness. But even in a scenario where the judge is
Not
relying,
evidence of non-dangerousness, you have other evidence that he does not need sex offender treatment.
Yes.
And I think the question is, can the judge just on their own decide based on nothing that someone needs sex offender treatment?
no, of course,
Well, I guess
but that wasn't, I don't think that was.
I mean, my question was a little different, which is if we don't have, let's say we don't know one way or the other what this recommendation on sex offender treatment is, but we know that a defendant tried to get sex offender treatment or any type of treatment, couldn't get on it, and the court is not holding it against them under factor 3, but is saying, I don't hold it against you, but I think you need it to not be dangerous. And so I find you still present a danger. Do you understand? I guess this does tie into Judge Easterly's question, which is what would be the factual basis for that.
Yes.
But my question is, in terms of availability of treatment, can that be separate from just the lack of treatment, perhaps under a different factor, like factor 5 or factor 11? Like, I know it wasn't your fault you didn't get it, but well, so let's take a hypothetical where it was recommended that he have such treatment, but he couldn't get it because he was on the wait list. He tried. Everyone agrees with that. So the court, let's say we agree with you that the court can't hold that against him under factor 3 because he tried, he just couldn't get off the wait list. Could the court hold that against him under a different factor by deeming him still dangerous because he has not received treatment?
If the court has a separate factual basis that goes to one of the other factors, then I think the court could look to those other factors and make that type of decision. But that is, of course, very different from what we have here, because the court's decision that Mr. Mohammed needed sex offender treatment isn't based on something in the record. It's not based on a competing expert report or anything that's coming from the BOP. It's just based on the court's own assumption. And
But the court does say, with respect to Dr. Keller's, I mean, I understand that Dr. Keller is the only expert here, but just because she's the only expert doesn't mean that the trial court has to credit everything that she says. And what he says is how he was concerned about an unanswered question that her written report left, how she came to her conclusion that Mr. Mohammed, who was indicted on 45 charges relating to stalking and sexually assaulting women, and especially who again was accused of stalking 2 women in 2016, would benefit from this type of treatment. He felt that her report was insufficient there. He did credit other parts of her report, but on this issue, which was central to him, he didn't.
So I think, Your Honor, there's a couple things there. First, it seems like the court is holding Dr. Keller's report to a higher standard than the preponderance of the evidence standard, because what he's doing is rejecting the report based on the fact that it was written and not on the fact that it, and because she didn't testify at the hearing.
Well, no, I mean, it's not because it was written. It was because he felt what was written didn't sufficiently address questions that he had about how she arrived at the conclusion that he didn't need sex offender treatment. That's different from saying, I want her here. I don't believe what's in this written report. It's just, I believe some of these things, but on this issue, I'm really troubled because the report doesn't answer that question. Well, what's wrong with that? That doesn't seem like it's holding the report to a higher standard. It's just saying, I read it, I credit some of it, but not everything.
So on page 18 of the order, the court does say Dr. Keller was not made available at the evidentiary hearing for questioning or cross-examination. So it seems like very clear from the court's own language that that is factoring into how the court is considering this. And then again, on page 15, the court writes, quote, the court did not have the opportunity to inquire of Dr. Keller about how she came to her conclusions about Mr. Muhammad. Dr. Keller's report actually does dive into the methodology that she uses. She talks about all of the different factors that she considers, including, the mitigation report, the inmate profile, the offenses, even going as far into Mr. Muhammad's city public school file. And so that's all there. And if the court wanted more information, IRA gave the court the ability to expand the record. And the court has the ability to, under 24-403-03B2, to direct the parties to expand the record by submitting additional testimony, examinations, or written materials related to the motion. So it's just false for the court to say that they couldn't have asked, that the court could not have asked for more information. It could have, and that information was in fact actually in part of the report.
So was the burden on the court to supplement the record, in other words, or was the burden on the moving party to put in evidence, sufficient evidence?
Well, the moving party did in fact put in evidence about the methodology, and then the court kind of dismissed it and said, well, this was all focused on
Dismiss it. It disagreed with some of it.
Well, it's not when the court is saying, it's not, this person wasn't made available. I didn't have the opportunity to inquire. That doesn't sound like the court is actually considering what Dr. Keller said, even though he does in different parts of his order kind of mention those things. When he does that, it sounds like he is actually just not taking into account based on something that was already there and provided to him in written format. He wanted more information and wanted the opportunity to talk to Dr. Keller. Now, this is something that Mr. Muhammad could not have known, and his counsel could not have known, because they did provide that evidence in the way that IRA allows. IRA specifically allows for evidence to be presented in written material, as in the form of a written material. And so if the court wanted more at that point, the court should have said so.
Counsel, can I ask, what's your position on how separable the dangerousness and interests of justice prongs are here? Let's just say, and I'm not saying you should take this as for anything more than a question, but if we think that there were no errors on the dangerousness side, and we think that there are now at least clearly errors under Riley and Doe on the interest of justice side, should we affirm, or do you think the interest of justice error bleeds into the dangerousness prong such that we need to send this back?
I think that the interest of justice analysis, is your question that if you find error?
If we disagree with you on all of your dangerousness
Yes.
arguments, would you agree that we'd have to affirm here because the interest of justice prong was sort of an alternative or
Yes.
an argument? You would agree with that?
Yes.
Okay.
So as to other evidence that Mr. Muhammad put into the record, Mr. Muhammad also put in a remorse letter, and the judge also discounted this because the judge, at the hearing, the judge told Mr. Muhammad on page 40 and 41 of the transcript that Mr. Muhammad is free to make a statement if he wishes, but does not have to. Again, on page 47, the court said the failure to say anything will not be held against him. But then later on, as part of the order on page 17, the judge wrote, the burden is on Mr. Muhammad to demonstrate that he is not dangerous, and he chose not to exercise the opportunity to testify at the hearing and describe any remorse he felt and why he believes he has matured while incarcerated. Again, that was a clear, the court had clearly told Mr. Muhammad that he did not have to speak at the hearing and it would not be held against him, and yet the court still held it against him as part of his order and discounted his remorse letter, which directly goes to factor 5, which is maturity and rehabilitation. And so the court erred by not taking that into account. And
If
of
the
course,
court had never said what it said, would it still be error?
yes, it would still be error because because IRA expressly allows for written materials and written submissions. And so Mr. Muhammad follow the directive of the statute and had no other notice. Now,
Sure, but a court still it's obligated to determine credibility even based on written submissions, right? I mean, obviously credibility based on demeanor is one thing, credibility based on written submissions is slightly different, but it's still a credibility determination at some level. And so what's to stop a court, even in the IRA context, when written submissions are permissible, to say, I just didn't find it credible? And if the court had never said to Mr. Muhammad, I completely understand if you don't want to testify, let's take that out of the picture. And the court just said, it was just in black and white and I just couldn't find it credible. Would you be making the same argument?
if the court is actually looking into the substance of what's in the evidence that's provided, then the court can make a credibility decision. What the court can't do is disagree with the format of the submission, unless the court provides another opportunity to speak or communicates that. The court, again, IRA allows for the expansion of the record. And so if the court feels that it needs more information, then it could go there. As for the availability argument, if I could just go back to that, I did just want to answer Judge Schrenker, one of your questions about whether or not C3 on its, if the only place that availability comes into play, if the only factor, if there's no other basis in the record to suggest that someone needs a treatment and the only factor that it's implicating is C3, then I think if programming is not available, then the language of the statute is clear, where it says whether the defendant has completed any educational, vocational, or other program where available. And that specific where available language was quoted by this court in Bishop in note 7, where it said, that it took note of the possibility that there may be some circumstances in which a lack of programming opportunities would excuse programming shortcomings. And again, citing to factor C3 and emphasizing the words where available. So I think the statutory language there counsels that if programming is not available at all. And I think that in a situation like where we have here, where this person has been on the wait list for 8 years, that is the kind of programming that is not available.
Can I ask a question, slightly different point? There were a couple of the IRA factors where the court found in favor of Mr. Muhammad. For example, I guess, did you want to address those, and perhaps was there evidence in his weighing of those factors that would further give weight to your arguments that he failed to properly weigh these other factors?
So, I mean, the court does weigh the expert report slightly in favor, but because when you look at the court's actual dangerousness analysis and where he's actually putting all of these different factors together to come to his ultimate conclusion, that's where he's discounting this evidence and focusing mostly on the fact that Dr. Keller was not made available at the hearing. And so I think that's a place where, the court is considering it to some extent, but not enough, and not in a way that accounts for what the burden is on preponderance, which is just more likely than not.
Thank you. You reserved a couple of minutes for rebuttal as well. Thank you.
May it please the court, Jordan Hummel on behalf of the United States. The trial court here did not abuse its discretion where it considered and weighed all of the evidence and arguments It explained which factors it found persuasive and why, and which factors it did not and why.
Counsel, wasn't Mr. Muhammad sort of in a catch-22 here? He, on the one hand, has, from what we know in the record, has a rating of minimal risk, and therefore he's on the lowest priority to get sexual offender treatment, which is why he was on the list for 8 years. And on the other hand, the trial court seems to penalize him, using appellate's words, for not getting treatment because it wasn't available and not likely to be available to him based on what we know of his rating on dangerousness and the availability, the limited availability of these treatment programs. So what is he supposed to do here?
Well, the court didn't penalize appellant for this, but he did say it was appellant's burden.
I think that's my word. I didn't mean to put words in appellant's mouth.
No, of course. So the court, I think it's important to note that the court did consider this under factor 3, where you have the programming, but also, I think more significantly, under factor 5 for rehabilitation and fitness to reenter society, and also factor 11 in considering the appellant's reentry plan. So I think more beyond checking a box of was this available or was this not available, the court was really focusing in on whether appellant understood, internalized, recognized that this is treatment that he actually needed, given the number of sex offenses.
Says who? Who said, I mean, it's, as you say, it's Mr. Muhammad's burden to show that he is not dangerous, and it's in the interests of justice to release him after being in prison for almost 40 years at age 60. So he puts together a presentation that says, I've done 1,600 hours of programming. I'm part of this UNICOR program that allows me to, work with minimal supervision in, trusted areas. I have a low, I'm in the lowest security designation for housing. My pattern score is very good. I haven't had any disciplinaries since 2016 or 2017. I am rehabilitated. And here's an expert report. Oh, here's my BOP individualized assessment. It doesn't call for sex offender treatment. And I've got an expert who's assessed me and not only talked to me on the phone for 2 hours, but contrary to what the trial court says, has actually reviewed all of my records. I mean, voluminous records. So the court mistakenly says that it's just based on a 2-hour phone call. But in fact, this expert has reviewed all of his records and says he doesn't need sex offender treatment. So he puts that before the trial court and says, here I am, and no one is saying that I need it, but I've signed up for it anyway because, I'm trying to do everything that I can. And then the court comes back and says, well, you need it. Based on what? What is the foundation for the court's assessment that he needs at age 60, 40 years in, that he needs sex offender treatment? I don't see a foundation for that statement in the record.
Well, I think as most sex offenders treatment starts with the underlying offenses where he did rape multiple women and
I
attempted to rape
understand.
another.
He committed heinous offenses 40 years ago, and that's why he's in prison now. And that is precisely what IRA relief is available, to people who've committed similar offenses. But he puts forward a presentation. He carries his burden of proof to say, here I am not dangerous. And you would think that if someone thinks that sex offender treatment is one of the main things that he must get to show non-dangerousness, that someone would rebut his presentation that he doesn't need it and that BOP doesn't think that he needs it. But there's no evidence in the record to support that he does need it. It's just the trial court extrapolating from his offenses from 40 years ago. So I'm just curious, do you think that that's sufficient? A judge can just say, I see that you have an expert report. I see that you have a BOP assessment that doesn't call for this, but I get to decide based on your offenses from 40 years ago that you need it. Is that how this works?
Well, the court looks beyond the nature of the offenses and then also looks at the more recent stalking infraction.
Well, let's
where-
put aside the stalking and infraction for a second, right? Just can the court just look at the nature of the offenses to decide that someone needs programming that the facility hasn't called for and no expert has called for?
I think here, especially if where the court disagreed with the expert, which of course the court is willing.
Well, let's put
is
that aside for
able
a
to do.
second too, because I think disagreeing with the expert is an affirmative evidence, right? So, and the government didn't ask to call the expert, ask to cross-examine the expert, object to the expert's absence, right? So do you think that the trial judge's assessment of the offenses from 40 years ago is a sufficient foundation for sex offender treatment?
It's difficult to say because the court didn't end with just the nature of the offenses.
I'm just asking the government's position, but you don't have an answer. Okay, so then talking about the expert,
Yeah.
and you say that the court didn't credit the expert. Why should we rely on the court's failure to credit the expert in toto, or on this point in particular, when the court incorrectly assessed the basis of the expert's report? I mean, the court said that all the expert did was talk to Mr. Muhammad on the phone for 2 hours. And that's wrong.
I believe that the court recognized that the expert did look at other materials. But the court also said that 2 hours was not a sufficient amount of time. And then including.
Right, but that's not all the expert did. I mean, if you look at the second page of the expert report, the expert lists 14 sources of information that includes the entirety of his disciplinary record, the entirety of his work history, the entirety of his educational programming, all of his medical records, his public school file. There are just numerous records in here that the expert looked at. So to say that the expert just relied on this 2-hour phone call would be just wrong. And if that is part of why the court discredits the expert, it really could give us pause as to the basis for discrediting the expert. Wouldn't you agree?
Yes, but beyond the 2-hour phone call, which the court does note, and I do think is significant, the court also mentions why it does not agree with the expert opinion, saying.
I mean, I just want to go back to the court says that the expert's report is, and I'm quoting, based solely on a 2-hour phone conversation. Solely means that's it.
I think that's referring to the interaction, the information that appellant gave personally, because the court also does note where it disagrees, where it says how it disagrees that the expert could look at the convictions, the charges, the underlying conduct, the multiple victims of the underlying offense and the more recent infraction and come to the conclusion that sex offender treatment is not needed. So I think that shows the court did understand that information, such as the disciplinary history, was also before the expert, but the court, within its discretion, disagreed.
Relies on the report from Dr. Keller and his pattern score to argue that he is no longer in need of sex offender treatment and that he is at low risk of reoffending. Dr. Keller's conclusions, however, are based solely on a 2-hour telephone conversation with Mr. Muhammad. That's wrong. Do you disagree?
Looking at page 15 of the decision.
Page 16 is what I just read.
Right. So, but I think before that, the court talks about and expands on other things that the report had considered, including the convictions, the charges, the conduct, multiple victims, this more recent infraction. This is, I believe, where the court gets into talking about how he was stalking or otherwise targeting women within the facility, referencing the infraction. So the court doesn't kind of blindly assume that the expert is only considering these 2 hours, given the holistic picture of the offenses of the more recent conduct, the court disagreed, as it's within its discretion to do, with the expert's ultimate conclusion that treatment wasn't necessary.
Counsel, can I ask you a slightly different question? So earlier you said that the court or that Mr. Muhammad got on the wait list,
Mhm.
but the record doesn't show that he made any other efforts after that. What efforts would those be?
I think there's two things. So there's the efforts before. So before he was in a BOP facility, and this is what the court said were kind of gaps in the record. And of course, it was defendant's burden to show, if he wants to show unavailability.
Well, we can get back to that, but at
Sure.
least after 2015, after he was on the wait list, and your filings in the trial court also said that he didn't show any further engagement on the issue, and I'm just not sure what that means. What more could he have done? And certainly, if he had been filing administrative grievances about not getting off the wait list, it seems like that would have been held against him. But what else could he have done?
Of course, we don't know that. I think what's significant is, so he signs up for the wait list. To be honest, I'm not sure if there's further actions he could have taken through the
Right,
facility,
so-
but it's significant that in his reentry plan, he also doesn't include any type of sex offender treatment, which shows.
But he's been
hasn't-
told he doesn't need it. Why would he hold that? Why would he put that against himself?
Well, I understand that the expert said that, but to the trial court, where the trial court is assessing, is this going to be a danger of committing more horrific sexually based offenses? Treatment is appropriate.
But it's being held against him that he didn't disagree with his own expert who told him that he didn't need sex offender treatment. And he should have said, I do need sex offender treatment, which at that point would have doomed his fate under IRA. And so
Well-
he either has to disagree with his own expert and require sex offender treatment of himself, or he has to not say anything to disagree with his own expert, and that's being held against him because he doesn't have the self-awareness that he needs sex offender treatment when he's been told that he doesn't need sex offender treatment.
Of course, that is the conclusion that the expert came to, but what was troubling to the trial court, which I think is reasonable, is that he lacks this awareness that these crimes have a sexual nature, that there is a sexual component to them that
Do you think he
could
lacks
benefit from
awareness that his convictions for rape had a sexual component? What's the basis for that statement?
I mean, under that logic, no defendant convicted of a sexual offense is eligible for IRA unless they've undergone sex offense treatment. Would you agree with that then?
I think that would be a reasonable conclusion, that if the goal is to make sure that they're not presenting a danger to the community,
I
that.
mean, it might be reasonable. It's just not part of the statute. Right? If you wanted that to be a precondition for IRA relief for sex offenders, you could see that the council could say, and all sex offenders have to have sex offender treatment in the statute. It's just not what the statute says. The statute says, show that you're not dangerous, look at these 11 factors, and put on evidence, which is what he did. And he went to the hearing, and the government, raises in sort of a tepid way, he hasn't done sex offender treatment, but just says it's a concern, doesn't put on evidence that he needs it, doesn't take a contrary position to his expert. So it's kind of coming out of nowhere when the trial judge says in his order, you needed sex offender treatment and you disregarded that. Right? I mean, the court says his willingness to seek and complete substance abuse treatment stands in sharp contrast to his unwillingness, at least for the first 33 years of incarceration, to even seek sex offender treatment. And it's just, I don't even know what the factual foundation for that statement is.
I think also, while the statute, of course, does not say that sex offender treatment is required, one of the factors is the rehabilitation, maturity, and fitness to re-enter society, which is one of the factors that the court analyzed with the lack of sex offender treatment here. And I do think that the contrast between the substance abuse treatment, where appellant's position is these crimes were all based on drug use, I'm willing to get treatment for that, where they are multiple rapes and multiple victims, it seems that sex offender treatment would be appropriate and certainly not an abuse of discretion
Counsel,
for
can
the court to
I
require.
ask I guess a slightly different question. What is your response to appellant's argument that if the trial court had this concern or question about why or whether sex offender treatment was needed prior to 2015 when appellant signed up for the wait list, was that the burden was on the trial court to ask for supplemental evidence or information for the record? What is the government's position on that? Do you read the statute in the same way, or do you read it differently? And I guess the same question goes to if the trial court had a concern about the expert not being there in person, or Mr. Muhammad not taking the stand and both submitting written reports, that it was up to the trial court to supplement the record.
So the statute is clear that it is the defendant's burden. The trial court has no burden to expand the record or to ask for additional evidence that would help a party to meet their burden if they think it hasn't been met. So we would disagree. It was the defendant's burden, his choice to present the evidence.
What do you think the point of that provision is?
I suppose if something came up in the court could do that, but the court certainly didn't have a responsibility to ask for additional evidence or to
I mean, it
ask
seems
for.
tailor-made for a situation like this where the defendant puts in evidence, government doesn't really contest it. Doesn't try to put in contrary evidence, doesn't say, we want to call this expert, we want to cross this expert, we want to expose that this expert is using improper methodology or is reaching conclusions that aren't supported by the evidence. And the court, has reservations, just sort of gut reservations and thinks, well, I want to hear a little bit more, right? Isn't that precisely, it just seems like the court in this situation sort of sandbagged Mr. Muhammad because the government didn't contest the defense evidence, just sort of vaguely said, well, we've got concerns that he hasn't done sex offender treatment, but doesn't actually put on any evidence that he's required to take it, doesn't have any evidence, it seems like, that he was required to have such treatment. And then the court holds this against them in its order. And it seems like this is the situation where if the court has concerns then and wants to test the evidence, it should call the expert in.
Well, the court certainly has the option of doing that, but I don't think that the court was obligated to.
Not obligated, but when the reason that the court then says, I'm not crediting this expert on this point is because I didn't see the expert, or it could have seen the expert, could have called the expert in. But right now, as the matter stands, the expert has put in a report where they have said, I not only talked to Mr. Muhammad for 2 hours, but I also reviewed all of these records, and the government hasn't contested the expert report.
And the government has no burden in this proceeding. So the fact that the government
Right.
doesn't
My
contest.
only point is
isn't-
there's only uncontested evidence in front of the court that he does not need sex offender treatment. Can I shift one gears to one other matter about programming generally? The court said, I think that the programming that Mr. Muhammad did was generally sort of low or insufficient because he did 1,600 hours over 40 years. Do you think that that's a correct way of calculating programming, that you just divide programming over a number of years served and figure out average number of programming hours per year, and that's how we should assess programming?
I think that's one possible way. I certainly don't think it's.
Do you think that's a reasonable way of doing it?
I don't think it's an abuse of discretion to look at it holistically and over the course.
Why
of
is that
incarceration.
holistically, I guess?
Well, to consider, 1,600 hours in 1 year of incarceration would read very different versus 42 years. And the court did credit.
For sure, but I mean, IRA is supposed to be a statute for, people who committed crimes when they were young and have served a long time in prison to show that they've been rehabilitated. Say that you have someone who committed a crime at 16, is tried as an adult, and for the first 10 years of their life in prison, they do no programming because they are still immature, not accepting responsibility, based on the science that we know about developing brains, they have just not accepted responsibility for the first 10 years of their incarceration. But thereafter, they do mature, they do realize that they should do programming, and they start to rehabilitate themselves. And 20 years in, they've done a significant amount of programming. Nonetheless, you think in that scenario that their aggregate number of programming should be divided by 20 years, not 10. I mean, that just seems contrary to the purpose of the statute.
I mean, I think in that case, the court could consider that what the time frame is within
Did the
which they were
court
taking it,
consider
but
what the time frame was in this case? Do we even know sort of when the programming happened vis-a-vis the 40 years in prison in this case?
I don't believe that that's in the record, but the court also did credit the programming and said that
I
a
get
lot
that
of
the
it was
court credited the
commendable.
programming, but the court also said it's really, it's minimally helpful to him, but it's not all that great because it's only 1,600 hours over 40 years. And if I divide that out, that's like 3.5 hours, or I can't even remember, can't do math. That's not why I'm on the
Either.
bench, on the fly. So, but in the end, that's not a big number for him for programming hours.
I think that is a significant part of the analysis, but also the court does grapple with it, does take into consideration appellant's argument that this was due to transfers and finds that that's not a sufficient explanation for why. But the court also does credit the significant work that he does with these.
There's also, there's a finite amount of programming available, generally speaking. Would you agree? I mean, I know you're not a BOP representative or expert, so maybe you don't know, but my understanding is that there's certain programming it's available, is not available. Prisoners who have taken a certain class are generally not allowed to take it again. They can't just pile up hours. They need to make these classes available to multiple prisoners. So a prisoner who's done 16 hours in 5 years, their denominator will necessarily be much smaller than the person who did 16 hours over 30 years.
Mhm.
But they've perhaps both taken all of the programming that's available to any prisoner who has been incarcerated in those certain institutions. And that seems like a weird thing to hold that denominator against the person who happens to have been in prison much longer at the time they seek IRA relief. My hypothetical was way off because you can't seek IRA relief if you've only been in prison for 3 years, but you get my point.
I do. And I think that that's all information, if that were the case, that the defendant could put before the court for them to consider and to, in an attempt to meet the burden, to show that they have done sufficient programming, that they would no longer present a dangerousness. Here, the record that was before the trial court just did not meet that burden to show that the programming he had completed was enough to overcome the court's conclusion that he did still present a danger to the community.
How do you respond to the appellant's argument that aside from the factual error of how the trial court considered the lack of sex abuse training, that there was a legal error of raising the standard of review when the trial court used the language that the low pattern score doesn't guarantee lack of dangerousness?
I think that the looking at the decision as a whole, it's clear that the preponderance standard was applied. Appellant's argument turns on this one word of guarantee. And I think the context is important in that statement where he was saying that the pattern score is a predictive tool, which is just a common sense statement. It's not a guarantee. None of these evaluations are a guarantee. And in order to find that the court applied the wrong standard, this court has said that you need to find sufficient language in serious tension with a preponderance, and a single mention of the word guarantee, where it's reciting a kind of common sense idea that a risk evaluation score can't guarantee future behavior, just doesn't meet that threshold.
Wait, you said that looking at the order as a whole, you can tell that the court applied the right standard. Where would you point me to in the order to show that the court applied the correct standard?
There are several mentions where the court says there's no support. There's either no support, no evidence, no mention. I'm looking at pages 12, 13, 14, where talking about different factors. We're just saying there's absolutely no evidence in the record for this particular point, which would show that it doesn't meet
But
that standard.
that's a little bit different, saying that there's no support for one contention or another versus sort of the overall, I find by a preponderance, that you haven't shown by a preponderance that you are not dangerous, right? I mean,
Yes, but it certainly shows that the court wasn't applying the wrong standard.
well,
That
I guess maybe I'm not following. Maybe you could show me what you're talking about as far as the no support, because it just seems like, okay, so Mr. Muhammad says, well, I did, 40 hours of programming, and the court says, well, there's no support for that. I think that there's only support that you did 30 hours of programming. That doesn't say anything to me as far as whether the court applied the correct burden of proof to Mr. Muhammad in showing that he was not dangerous. So I guess I'm not following what you're pointing me to show that the court actually understood what the burden was.
Sure. So in the court, talking about the lack of sex offender treatment programs on 13, says there's no evidence until quite recently he ever sought to enroll in any of the treatment programs. He's complete on 14, the appellant completely failed to establish any effort again to enroll in the programs, and the lack of enrolling in the program showing a lack of rehabilitation to reenter society. So even if it doesn't necessarily establish, the court's not saying it's applying a preponderance standard. Of course, if there is no evidence in the record, it wouldn't meet that standard. And to
Well, not
find,
necessarily. I mean, it depends on how.
It wouldn't meet a clear and
important you-
convincing standard either, right? Sorry.
yes,
Yeah,
but the court's in.
but I don't think, I, just to jump back in, I don't see, I mean, if you don't think that his failure to do sex offender treatment more than 9 years ago is very important in showing that he is dangerous now, or that he's failed to show that he is not dangerous now. I mean, it is, again, that seems much more like my example of, well, he says he's done 40 hours, but I only see evidence of 30. He says he's on the waiting list, he's been on the waiting list for 8 years. I don't see evidence that he tried to do sex offender treatment, before that. I just don't understand why that is illuminating as far as what the court understood the actual burden for Mr. Muhammad to be, to show that he was not dangerous. It just seems apples and oranges to me.
I take the court's point. And of course, there is a presumption that the court applied the correct standard, and the
There's
default
a presumption,
standard.
but then we get back to the fact that the court said there's this pattern score doesn't guarantee that he's not dangerous, which is not the
Yes.
measure.
I
That's
think
not
a
the
single
yardstick.
word, a single mention of the word guarantee, again, in the
Right, but it's a
context.
single word when there's nothing else in the order to indicate. I mean, I've been asking, what else is in there to show me that the court understood what the actual standard was?
It is a single, and while it may not signal a preponderance, it's certainly not in serious tension. Whereas in Bailey, we had multiple instances of the court saying things like must be confident, ensuring the record demonstrates sufficient comfort that there's non-dangerousness. It just doesn't rise to that level in that single mention of the word guarantee.
Can I ask you,
I'm sorry. When we look at the evidence here, while we've said that the moving party under IRA has the burden of persuasion, here there's nothing else on the other side. The government's not required to present any evidence, but they didn't present any evidence rebutting the expert or any of the testimony. Suppose appellant had put in 3 experts, and again, no rebuttal expert from the government. I guess, and the court doesn't credit them.
Mhm.
Is the court free to do that? Discredit any and every piece of evidence that the appellant puts in when there's nothing on the other side to rebut it?
Of course, it depends on the expert, and you would need to look into why the court did not credit those experts. But yes, if the appellant puts forth 3 experts that the court disagrees with, as long as the court gives an adequate explanation about why they disagree, I think
so
that would
can
be
I
sufficient.
follow? Oh, wait.
Just one last thought. So here where the court accredited portions of the expert's witness statement and discredited other parts. How is that sufficient under the preponderance of the evidence standard, where there was no other testimony rebutting the
So I think
expert?
because the court, is again, free to disagree with the expert, and it explained why it did so, finding that, the 2-hour conversation wasn't sufficient. He thought the other evidence that was in the record before the expert was contradictory to her conclusion.
So going to explaining what the court finds unpersuasive or does not credit in evidence, what was there said about Mr. Muhammad's letter of remorse that led the court to find it not credible in and of itself, such that it required him to have appeared on the stand when the court told him he didn't need to?
Well, the court didn't require him to appear on the stand. The court acknowledged that he has no legal obligation. The court did that in the hearing and again in the opinion. He just noted that to the extent the court had reservations about the letter, that is one piece of evidence that appellant could have introduced that may have swayed the court.
Right, but that's the thing. What were the reservations about the letter? See, you could have a letter where the defendant says, I have remorse, I feel bad about what I did, and then 3 sentences later says, but I still maintain my innocence, and those people had it coming to them, right? That would be 2 things in the same black and white document that are contradictory and would give someone a basis to not credit that letter. But the court didn't point to anything like that, right? And I don't see anything like that in the letter.
No, the court didn't point to any particular statement, but did say that the question for the court was whether the appellant had authored it himself, whether somebody else had edited it, whether these were his true feelings. So it really went to the weight of the letter, how convincing the letter was to the court, which the court could have explained more, but the court never drew an adverse inference against the appellant for not testifying.
Well, I mean, I
again,
think the court explicitly did, right? I mean, without pointing to anything in the letter that was contradictory or called its credibility into question itself, other than the theoretical possibility that it could have been written by somebody else, the court then said, without you appearing on the stand, I just can't credit your letter. That seems not only directly contradictory to what the court told Mr. Muhammad, but also just inconsistent with the statute itself.
well, the court also, I think, in the next sentence acknowledges there is no legal obligation to testify. The court is very clear about that, both on the record during the hearing and in the decision. And then the court, when it's talking about the letter, says quote, decision not to testify made it more difficult for the court to assess the letter. So the court's not rejecting the letter. It's not saying I don't credit the letter. It's just saying that it adjusted the weight that it gave the letter as far as remorse was concerned. And of course, it doesn't seem that this piece of evidence, if the court had considered it differently, would have changed the outcome of the dangerousness given the lack of the treatment and the later infraction that the court did say serious concerns about.
I have one hopefully quick question. Art, is it fair to say that after Riley and Doe, you would concede error on the interest of justice prong or no?
Yes.
Okay.
But we would ask that the court affirm on the dangerousness prong.
All right, thank you. All right, thank you.
Thank you.
All right, Mr. Brill, you reserved a few minutes for rebuttal.
Yes, thank you. I just wanted to clarify that Mr. Muhammad has counsel at the hearing stipulated that he would be willing to do this treatment upon release if CSOSA deemed it appropriate. And so that also kind of affects.
That was a question I had. Could the court have ordered that as a condition of release that he go to sex offender treatment?
I think the court could have ordered that Mr. Muhammad comply with whatever CSOSA has deemed it appropriate. I think on this record, for the court to make that kind of order without a factual predicate, I think that would be, I think that he would need a factual predicate for that decision.
Right, but he could have said, if
Yes.
DeSosa thinks that you need to go to sex offender treatment,
Yes.
you've got to go to sex offender
Yeah.
treatment.
And then looking at the record as a whole, it's clear that Mr. Mohammed has met the preponderance of the evidence standard. The BOP factors themselves took into the account the nature of his conviction, his disciplinary history, his programming, and found that he was at low risk of recidivism even without this treatment. So the record is clear that he does not need it. And then finally, because of that, because the IRA court lacked a factual predicate for requiring this programming, this court does not have to reach the statutory question of availability, because you can find that he was non-dangerous and there's not record support for the fact that he needs it. And so this is not a case where the only thing keeping Mr. Mohammed from release is the lack of availability of treatment.
So you're, I'm sorry.
Are you asking for the court to remand it for the trial court to make certain redeterminations? And if so, why and which ones? Or are you, why, I'm sure you prefer a outright affirmance, but if we were of the view that it needed to be remanded, what should happen on remand?
So we would ask that this court reverse and release Mr. Mohammed because we believe that the trial court only had but one option on this record and without abusing its discretion, and that would be to order release. But at the very least, this court should order a remand so the trial court can apply the correct legal standard and reevaluate Mr. Mohammed's IRA petition.
We have the correct legal standard, and how would the trial court do that here?
So the trial court should review the articulated factors in the IRA statute and make a decision utilizing the facts that are actually in the record. And so because there are no facts showing that Mr. Mohammed needs sex offender treatment, there's no predicate for that decision. And the court talks about sex offender treatment in factors C3, C5, and C11. And then finally, while talking about its dangerousness conclusions, and then the court should evaluate the evidence that is in the record that is supportive of Mr. Mohammed and give it the correct weight. And so not considering the pattern score, the remorse letter, the expert report, that goes to factors C3, C5, and C11 was a critical omission. And so the court should properly weigh those factors.
I mean, maybe your argument is we don't know what the court would do if it did this correctly, but theoretically, one could say that if the court had said and I know you have issues with the stalking sort of findings, but Mr. Mohammed made these sort of threats or harassment of these female BOP employees, including saying I have a life sentence, so what do I have to lose? It's something I think violent in that statement itself. Court says that's enough for me, dangerous, no IRA relief. Was that something we would really overturn on an abuse of discretion review?
So I think it's important to note what the court is actually doing when it's taking into account that 2016 disciplinary incident. The government only argues that 2016 disciplinary incident goes to show proof that Mr. Mohammed needs sex offender treatment. Again, this is contradicted by the record. The BOP takes this disciplinary incident into account, and so does Mr. Mohammed's expert. And both of them conclude that even with this, he's still at low risk of recidivism. But instead, what the court is doing is focused on the word stalking. And the court says at the hearing, when I see stalking, it seems to me in some way similar to following somebody in a vehicle, smashing into a vehicle, and then sexually assaulting them. That's an assumption that the court is making, that what is happening here, which is that Mr. Mohammed is filing repeated grievances and annoying BOP staff, is the same or could be connected to and therefore require sex offender treatment because he might file grievances in BOP and then go outside and physically assault and sexually assault people. There's not that connection. And so the court, the inference that the judge is making is unsupported by that specific incident.
You said that on this record, in your view, there's a sufficient basis such that there was only one conclusion the trial judge could have reached, which was to grant relief under IRA and release Mr. Muhammad. What if the trial judge had, for all the same reasons on the record, decided to shorten his sentence by just a few years as opposed to completely release him? We've upheld in other IRA cases that that was fine. Why wouldn't that have been an option available here?
The court would still need a factual basis in the record to explain why a reduction is appropriate as opposed to release. This is someone who is non-dangerous by every other factor in the record, except for this court's assumption that Mr. Muhammad needs sex offender treatment. Once you remove that assumption, because it's not based in the record, there's not much else there. And so there's not much to support any kind of assertion that a reduction in the sentence is appropriate rather than reversal or immediate release. Well, thank you.
Anything further? All right, court thanks both counsel for your briefs and arguments today and matters taken under advisement.
Thank you.
All rise.